And so we have huge, an extraordinarily good education system for the elite. You can stratify Indian society into different layers, and these layers correspond to their socio-economic prosperity. And if you stratify them, you can correspondingly find a particular type of school. For the elite in India, you have the international schools. I'm sure that will beat schools in the United Kingdom and the United States of America. But that's for a few people. And then comes the schools which are meant for, the children of top politicians and top bureaucrats. It's called the ICSE system. What's the full form of that, person?
International
Indian School Certificate, something like that. Then the third layer is the CBSE schools, the Central Board for Secondary Education. Then the fourth layer is government schools, state, and there if it is for the middle class, then it functions. And the last is the primary school for the vast section of the population. These schools don't function at all. And it is there that the tragedy occurs. So if a school is not functioning, then the tendency is for that child to be drawn into child labor. So a solution which child labor activists suggest is, how do you make the school function? And in this regard, there has been a lot of activism. As a result of that activism, the Supreme Court of India came out with a path-breaking jurisprudence in human rights. Perhaps there is no other agency in the world which has done this. And that is, it combined the economic, social, cultural right of education, which was then contained in Article 45 of our Constitution. It was equivalent to economic, social and cultural rights and therefore not considered to be enforceable. What the Supreme Court said was that when a child does not get education, then it actually amounts to a denial of the right to life. Right to life is a civil and political right. It's contained in Fundamental Rights chapter of the Constitution. Supreme Court said that if you want the right to life, there must be dignity. And if you want to get dignity, you can't have it without education. And therefore the right to education, which was otherwise economic, social, cultural right, was converted into a civil and political right and made enforceable. And this is, I think, an outstanding judgment of the Supreme Court of India. I don't know of any other jurisdiction in the world which has done this. It has collapsed the distinction between economic, social and cultural and civil. Of course, we say human rights are indivisible, but that's in theory. In reality, it was for the first time the Supreme Court did that. And as a result of that judgment, then the Constitution of India was amended and Article 21A was introduced in order to make education a fundamental right. Unnikrishnan's case. Justice Jeevan Reddy delivered the judgment. And after the fundamental right was introduced, now there is a statute which makes compulsory education, which makes education free and compulsory. So you a tremendous transformation, and that is why I have thought during the limited time that we have, this is one entry point so far as Indian jurisprudence in relation to child rights is concerned. If I may take just a few more minutes and mention one area where recently we found tremendous value from experiences in the United States of America, and that is, there is an increasing situation of child abuse, especially sexual abuse of children. Abuse is an inappropriate word in that context. It's sexual assault. It has been rape. It's been molestation. It's a shameful variety of sexual offenses against children. And what is unbelievable is even infants have been victims of this. You can't imagine. Many colleagues who are in the field of activism point out that sometimes it's a 3-year-old child who has been raped. And so that offense has now been taken cognizance of in India in a big way. some of us were involved in drafting the law for protecting the child against sexual abuse. And what makes it very difficult is very often, and sociological survey in India points out to that, it's actually incest. Sometimes it's the father, sometimes it's the uncle or the cousin or somebody who frequents the house. More often than not, it is somebody known to the child who has violated the child. And that makes the administration of justice even more difficult. And therefore, while we were set out to draft this law, we had to look at the substantive offences that are there in the Indian Penal Code. And we found that it was hopelessly inadequate. That's when we looked at comparative jurisprudence in the USA, in UK, in Canada, in 12 countries. And we found that the sexual abuse jurisprudence has grown quite a lot across the world. You may be aware that feminists have attacked the substantive offences relating to sexual offences from a particular point of view. They have said that most criminal law jurisprudence is overly concentrated on peno-vaginal penetration. They have pointed out that this is inadequate. And as a result of it, there's a whole expansion of what is the range of criminal offences. It goes far beyond just peno-vaginal penetration. And so we were able to list more than 25 offences relating to children. And the categorization of offences in relation to pornography in the United States of America is probably the most advanced. Maybe some of it is not even applicable because of the way technology has developed in the USA. But more important than just the mention of substantive offences, we found the Indian Penal Code cannot contain it. Therefore, we have recommended that all these offences against children must be contained in a separate statute with a separate procedure. I come to procedure, which is where we learned hugely from the American experience. I dare say, compared to all other jurisdictions in the world, we found the American experience the most useful in this regard. And that is, the proposition is very important to take note of. And the proposition is, when it comes to criminal justice administration, it's a world of adults. Completely dominated by adults. The policeman knows only how to deal with adults or how to deal wrongly with adults. The prosecution, public prosecutor knows only how to deal with the adults. The judge knows only how to deal with the adults. And so the whole criminal justice administration is adult-centric. And then you bring this poor child, a girl child very often, put the child into the witness box and subject the child to cross-examination, and the child ends up going through another rape. This time committed in the judiciary, and that's called re-victimization. After having been victimized once, you once again strip the child in the witness box and subject that child to infliction in the name of fair procedure. Therefore, we objected to it and we found American federal law very useful. And I must say that American federal law has introduced several dimensions which Indian jurisprudence during the last few months we were struggling to take it home. And we found huge resistance from the judges, from criminal lawyers. Criminal lawyers who appear for the accused could not for a moment think that a child need not be put to cross-examination in the same manner in which an adult is put to cross-examination. And the United States of America provides another way in which such cross-examination may be conducted. You might have a CCTV. The evidence of the child is recorded not in the presence of the accused. The important thing is how to avoid eye contact between the accused and the child victim. And therefore you can use TV and have it recorded. The judge may sit with the child in a particular chamber and the accused may be in another place, and then electronically you provide the necessary. So the difficulty was to balance principles of fair trial, because if there is instrumental use of the child, very often in a matrimonial dispute, it can so happen that the accusation of sexual abuse is a trumped up accusation, and therefore fair trial must also be ensured. So how do you balance a child right with fair trial? I found this the most fascinating area for invoking the Convention on the Rights of the Child, and for invoking learning from comparative jurisprudence. And so we found the USA, UK, and some countries in Africa useful. I think my time is more than up, and so I shall now wind up. And I thank you for this opportunity, and I hope your discussions in this regard will be fruitful, and I hope this will be the beginning of a kind of jurisprudential exchange between India and USA, which will go into many more areas. Thank you.
Government. So there's that political resistance in the constitutional structure. And the right to education, our U.S. Supreme Court has held that there is not a fundamental right to education. Now, many, if not all, all the states have their own constitutions also. They have to be consistent with the U.S. Constitution, but they can also give greater rights than the U.S. Constitution. So oftentimes this right to education comes in the state constitution. Now it is not, again, because of the convention provides this right specifically to children, there's been some resistance by the U.S. government to ratify it because it would mean then telling the states they would have to do it. Most of them are doing it anyways, but not all. And there's a political tension there. I expect that probably now that this death penalty issue is out of the way, that there will be some, that it will be ratified at some point, particularly under the current administration. One of the things I wanted to mention, you'll see in your problem, is to have you think about both legal and non-legal, and I don't mean illegal, ways to approach human rights problems. You might say, well, our Constitution says this, you can file a PIL, or you can file a civil rights case in the United States. But human rights workers also, and NGOs, organize and do, you saw at the Indian Institute, they made films. There may be a letter writing campaign, there may be a demonstration, there may be different ways to pressure the government. And in your small groups, you should talk about both what the law is, but how to address this human rights problem, both through the typical litigation or passing of statutes, but also in other kinds of ways. I had a wonderful professor when I went to law school named Louis Henkin, who was a famous international scholar, and he said, one time in class, he said human rights is mobilizing shame. And when it comes to the issue of child labor, and in the U.S. we have, in the U.S. students will talk about this, we have certain laws to protect children from being taken from school and working 40 hours. I'm not saying it doesn't exist, particularly in certain populations like migrant communities, and Professor Maroof may speak today or tomorrow about that a little bit, that experience. But a lot of it is multinational companies that are based in the U.S. will then export and have the work done in another country, let's say Indonesia. And that's where the child labor abuses occur. But they're not, the legal question is, are they subject to the laws of the United States for something that's done in another country? And are they doing it, or is another company just selling it to them? And that's an issue for discussion in your small groups. The last thing Professor mentioned was the issue of how do you deal with a child who's been subject to sexual abuse, and my God knows, if this was a 4-year-old child who had been abused by, let's say, an uncle, and to sit across the room, not even across the room, very close to that person and testify against that person is also, the psychologist will tell you, that's a trauma to the child also. there was a U.S. Supreme Court case that said in the criminal, we have something called the Confrontation Clause, and it applies only in criminal proceedings. That means that the accused has the right to see and ask, have their attorney or themselves ask questions, cross-examination of any witness. And the U.S. Supreme Court 5 years ago, in a case called, I won't get into the details of that, indicated that a procedure that one state used, the state of Maryland, where the child was not in a position to have to see the person who is accused of sexually assaulting the child. Since then, there have been some cases on the Confrontation Clause about the right to, and it comes from the case, you might know about Sir Walter Raleigh's trial when he was convicted for treason, and there was, the person who was testifying against him was not there, and a man just stood and read. That's where that comes from. And so in the Confrontation Clause, now it's been held that the accused has a right to ask questions and see, because Sir Walter Raleigh said that man will not lie about what I did if he has to look me in the eye. And then the question, so that Confrontation Clause right has been expanded, and the question, which is unanswered right now, and because it's a very new group of cases, and it's causing a lot of disruption in our criminal appellate system, is did this case from the state of Maryland that said a child can not be in direct contact with the accused, is that still permissible under these new cases? And we don't know how far that will go, and that's an issue that's unanswered, but it's certainly an issue of concern for child advocates because of the trauma. But then we have this constitutional fundamental right that you have a right to confront the witness, and that's been interpreted to mean to be there and be able to see each other and have that person look you in the eyeball. So I just wanted to point out a couple American versions of the issues that the professor raised, and we'll deal with some of the issues around children and women in prisons when we cover that another day. I don't know if Professor Maroof may touch on the experience of children in refugee immigration situation, because they're when you went to one of the field placements, this is a vulnerable group, and their experience in the immigration process and refugee process is very different than adults, and that's an area of her expertise, not mine. So she'll talk about that. So I just want to touch quickly on those points mostly for the Indian students, and to remind that the U.S. students about some of these issues that hopefully you're aware. Professor Prasad has your small group assignment.
Activity was related to child labor. Now within child labor,
one thing,
yeah,
everybody doesn't know the problem we are given.
Alright.
So please first explain
I'm introducing it. Yeah.
your problem, and then
Alright.
Not personal problem.
It's okay. So the first question to be considered was, should there be like a difference between child work and child labor? The definition. What kind of work should be prohibited or legally allowed? Or should there be such a difference or not in the first time? The second thing is that, what was the second thing I forgot? Okay, and basically there are two views. One view says that all forms of child labor all forms of child work should be called child labor and should be prohibited legally. Whereas there's another view that some sort of work is allowed, some part of work should be there. Like some people grow up in farms, so while getting educated, they might help out their families in the farm. So that shouldn't be, made illegal or anything. So child work, the concept of child work should be different from child labor. That's one view, and the other view says that all forms of child work should be banned. So what we agreed upon was that there should be a line of difference, and
so essentially there was 4 kinds of work, and it said how should you treat children based on that work. A common experience for American students is distributing newspapers, having a newspaper route, which is like part-time work. In India, they had the thing about helping parents with weaving at home as like a part-time, I guess, cottage industry. And then for like a kind of heavier industry, what you would think of traditional child labor, you'd have working in a factory in America or working in a stone quarry in India. And we essentially agreed that the common American experience is to have a part-time job, or in high school at least, or a little, maybe even a little bit earlier, like, or if you have a farm, working on the farm, or do newspapers. In India, we found that for most middle class and upper class students, they don't have a job right before they. That's just a social thing, because the people that do child work in India, we find they do it out of necessity, not out of, I want some extra spending money so I can go to the movies on Friday night, which I think is mostly the American experience. One thing we noted was that in Article 32 of the Convention on the Rights of the Child, there's 2 things that stick out, and that's any work that is hazardous or interferes with a child's education. So we would think like something, even in India, like working on the family farm, as long as you're able to get to school and you have time to study, that wouldn't be interfering. And another thing would be harmful to the child's health or physical education. So obviously there's a lot of industries, like even I see around here, like children carrying bricks and working on buildings and stuff. I mean, the chance for injury is much higher, especially when you're a child. You don't fully comprehend the dangers of being up high and stuff like that. You're not as careful. So I think something like that would fall under to what this Article 32 thing. And then talk about the legislation.
Okay. So then the legal and the non-legal protection. Under legal protection in India, we have a Child Labour Prohibition and Regulation Act. Now the thing is, it has 2 schedules, and it mentions a list of things that are prohibited. A list of processes and kind of work that is absolutely prohibited. Like for example, working in a quarry or a mine is absolutely prohibited, whereas there is a list of things that a person can do, a child can be made to do or work, but it has to be regulated. Now the regulations are like there has to be a register that has to be maintained with the name of the child and the age, and there can be an inspector who actually comes and inspects that register and sees the conditions that the child is working under. There are a limited number of hours, I'm not sure how many, that the child is supposed to work in. And those things could be like bangle making or weaving. That kind of work is allowed. The problem in India is that the law isn't actually being implemented properly, because of the attitude of the people. The core problem in India is that most of the poor families are, obviously illiterate and not educated, and they believe that more the number of children in the house, the more the it'll result in more income for the family. So that kind of attitude has to be changed, and so education is important, awareness is important. So the non-legal aspect will help implementing child labor laws in India, because the law is there, but it's falling inadequate in implementation.
Also, we kind of came to the conclusion that the law that was passed in India is not really enforced. The enforcement's the biggest problem. In America, it's kind of different. Like if a cop was to drive by and he would see like children working in a stone quarry, he'd obviously stop his car and ask them what's going on, even if it wasn't his duty to do that. Here, even officers whose duty it is to stamp out child labor kind of just turn a blind eye when they're, we take the bus and we see children doing all sorts of stuff. So we found that enforcement of the act is there, but like with many things, it's the actual enforcement is not present.
Exactly. Another thing is Article 32 provides that there has to be a minimum age. So the minimum age under the act that I mentioned is 14 years. Yeah. It's not 18. So the definition of a child under the act specifically is 14 and below. And
If I just throw it, are you guys going to get to the sliding?
What?
You can
the line. You can talk about it.
In relation to all these things, we also talked about how that line between work versus labor. Work is somehow edifying, or it helps in the development of a person, whereas labor tends to be more life. It's exploitation, or it's degrading in some way. And that in reality, though, where that line is between work versus labor is very difficult to determine. And, you know, it's nice to say, let's just make a firm line and it's everyone should be this way, but the reality is you know, the professor in his opening remarks talked about like the development of capitalism and civil and political rights and how all those things develop. And the reality is, like, how do you know, even within India, there may be differences between urban population and a rural population, and where should that line be? Because it may be that in certain places it is beneficial to have children more involved in the labor pool in a constructive way, and in other places it's less. Or how, for instance, in the middle class in the United States and in India, kids oftentimes don't work. You know, previously in the United States, they did more but less now, whereas in India it was less before, and now they're working more summer jobs. But there's lots of issues, and there's not a cookie cutter solution. So, you know, how do you actually apply that? I don't think we had a good answer to that.
I think, just to add to what he's saying, I think in India, like, for example, let's take the traditional industry, like we see a lot of inlaid marble or engraved, like beautiful work is done, children learn that from a young age. So is that a form of education for them to be doing? I mean, if that's what they're going to do their whole life and that's their choice to do it, I mean, you know, it's like an apprenticeship we have in America for skilled trades. I mean, you go to the normal classroom for a certain amount of time, but then you do that type of work. I mean, so you have to define exactly, I think, also what is education. Is that like a form of clinical or practical education, like a plumber would do?
Vocational.
Yeah, vocational. So, I mean, the only way they're going to learn to do that, they're not going to sit in a classroom and learn how to inlay marble. They're going to actually physically sit there in a stone quarry somewhere and do it. So, I mean, that's also a problem too, I think, with trying to enumerate or...
I think they also need to define who is capable of entering into an employment contract, rather than like, is this education, is this employment, is this labor?
We came to the conclusion that most of the child labor here is not actually like by choice. To get into a contract, you'd have to be, it most likely be a choice. Probably most of the child labor is forced.
Yeah, and we're discussing manual labor. There is no contracts, anything. People just like...
Yeah, like they can't even
it's
read.
Daily wages. So there is, it's all unorganized sector, you know. Yeah. Children are working in the unorganized sector. So the
you have to have the
point of a contract
doesn't
really
if you can't read,
come up. Yeah.
Somebody could put anything in front of you and...
Exactly.
So like if there's no capacity to even enter into, like, it's, even if it's a daily thing, like you're entering for a day, like into a contract in a way, like it's, you don't, it doesn't, a contract doesn't have to be written.
Okay, you're talking about an oral agreement,
right.
Yeah.
So if the child doesn't have that legal capacity, like, is that even considered work? Is that even considered?
Like we said, they don't even enforce that the child is working in a thing. Do you think they're going to take the time to look at if there was proper, like...
No, but she's saying, but actually under the act, they can be allowed to work. So.
You know, if the deal or the conditions are being honored that was said they were going to, like...
No, I'm not even saying, like, whether the child understands or not. Like, I'm saying, like, does the child, like, has the government given the child the legal right to enter into...
I think under the act, in an implied way, when the act says regulation, that means there are certain kinds of work that the child can legally do. So by implication, I guess it's legally allowed, right?
The law says basically if you are non-hazardous industries,
then you can work.
Legitimately work, but not long hours, I think 6 hours, and then it is the duty of the employer to provide education and sufficient leisure. But it doesn't happen. Therefore, the Goa has passed a comprehensive Children's Act, and I'll tell you, it says child employment below 14 years is absolutely prohibited. That means neither children work, or whether you call it as a work or a labor, both are prohibited. Even non-hazardous industries, you cannot work. And they imposed a penalty of 50,000 rupees on the employer if they employ a child below the age of 14 years on anything, including hazardous, non-hazardous and domestic. So if it is hazardous 50,000, non-hazardous 25,000, and in case of a domestic help, which is very rampant particularly in the major towns in India, that means you employ a child in your home to take care of your children. And domestic work is the worst form of exploitation because it's a 24-hour job. The child will be in your home, and you are sleeping when your child is crying, and the other child will be taking care of your child. So for that 25,000 they mentioned. But reality, what happens?
There's no enforcement.
There are so many children still working in Goa. What happened to your penalty? It is only on paper. So the question that Professor Matthew is asking you is, do we accept the reality that the child labor is there going to exist, and therefore we give a better protection, allowing them to work at least to some areas and a better enactment, or completely ban it?
I think the former.
That's correct. As you said that according to the child work, it shouldn't be less than 14 years old. But as you know, most of the Indian laws put for what we can say the responsibility of the person to be a full, what we can say, awareness in majority, and for any kinds of the activities like for a marriage or for joining of the soldiers army, it should be at least 18 years old. So do you think that there is some kinds of the clash between, for the understanding between putting of the 14 years olds and the
there is a difference. I think for practical reasons they've made it
18 years old. Do you think that there is some kinds of...
I think for practical reasons they've made it 14 because we discussed this, right?
Because like, for example, somebody's going to be a plumber or something like that. They get that education up to 14 where they can learn how to read and write and basic skills, and then after 14 they can go on work and learn their trade.
I think
we're done.
We'll discuss it later.
I understand there will be a lot of concern for this.
And just one thing, I've forgotten the constitutional provision for again, right against exploitation. I've forgotten the provision. 24, Article 24. So that's important.
While we're transitioning, can I just throw it?
Yeah.
We don't want to paint two roads to a picture in the United States because migrant labor, there's 10 to 20 million people in the United States where we have all these exact same problems, so we're not a perfect world. So I just want to throw that out.
Yeah. Okay, thank you.
All right, for our group, we had, in India, the juvenile justice laws draws a distinction between 1, children in need of care and protection, and 2, children in conflict with the law. The second category of children are exempted from the criminal justice administration system for adults. What are the legal and non-legal protections available? And our reference was Article 40 of the Child Rights Convention. Basically, Article 40 wants to protect a child's dignity and worth, and they want children to assume a constructive role in society. So a child who is in violation of a law, the courts will operate under the presumption of that this child is innocent until proven guilty. They have to be informed of the charges against them, and their parents will their parents or guardians will get them the appropriate legal assistance for their defense. The child is entitled to a fair hearing by an independent and impartial body. The child cannot be compelled to testify against himself. He has the right to confront the witnesses to be used against him. He has the right to appeal. Also, the child is guaranteed an interpreter free of cost, which we weren't sure about whether this was afforded to children in the U.S. I don't know if anybody else knows if a child gets free interpretation.
I just wanted to point out that the case that gave children these rights for proceeding, if you want to look it up, is called In Re Vinci.
Awesome. Article 40 went some further steps by ensuring that the child's privacy was respected throughout this entire process. We weren't sure in what capacity that was supposed to be. And then also like a factor for the child that they would consider was their mental capacity, whether they knew the difference between right and wrong. And in the U.S., we have juvenile justice courts, so